Hi, my name is Jack McKenna. I'm a certified civil mediation counsel, CMC mediator. This discussion is in regard to the level of unheard court cases in England and Wales. Specifically, the groaning level of unheard court cases. And is the question, is it all of the UK or just England and Wales? What is the number of unheard court cases? A total of 78,000 has been quoted. Is this all of the UK or just England and Wales? One wonders what the total would be for England, Wales, Scotland, and Northern Ireland. Again, I'm Jack McKenna, CMC certified mediator. Jack_McKenna at mediationintexas.com. The Lamy solution. Reforms must be handled carefully. David Lammy currently holds the positions of Deputy Prime Minister, Lord Chancellor, and Secretary of State for Justice. The message is carry on reforming. Where are Kenneth Williams, Sid James, Hattie Jakes, and Charles Hawtrey when we really need them? The Times editorial states that we have rightly argued that there are great inefficiencies in the system that need to be tackled, such as the digitalization of paperwork and extending sitting hours. It is easy to blame the pandemic for the groaning level of unheard cases, but years of underfunding have also played a part. Providing more monies so courts can sit longer is a must. Mr. Lammy is right that the status quo cannot go on, but any reforms must be handled carefully, and that is brilliant advice. Could this work? Reducing the court backlog, a layered justice reform strategy, a structural reform, ADR, restorative justice, system efficiency, and this has been prepared for the Bar Council of England and Wales and the Ministry of Justice. The problem: court backlogs undermine access to justice and public confidence. Capacity expansion alone cannot solve the problem. Demand side reduction is essential. Why a single solution will fail? More sitting days do not reduce incoming caseloads. Recruitment lags demand. Serious cases crowd out lower complexity disputes. The layered reform model: structural criminal court reform, ADR for civil disputes, restorative justice and diversion pathways, early triage, and procedural efficiency. Restorative justice, RJ, out-of-court resolutions, OOCRs, and deferred prosecutions are complementary tools designed to resolve certain offences without a full court trial, while maintaining accountability and victim involvement. RJ focuses on repairing harm rather than punishment alone. It brings together the victim, the offender, and a trained facilitator, where appropriate, to acknowledge harm, agree steps to make amends, apology, restitution, community action, and support closure for the victim. OOCRs allow the police or prosecutors to resolve suitable, typically lower level offences outside the courtroom through cautions, conditional cautions, community resolutions, or similar measures, thus avoiding prosecution where public interest tests are met. Deferred prosecutions: they pause formal charges on conditions that the offender complies with agreed requirements, for example, restitution, treatment, behaviour change. If conditions are met, prosecution is discontinued. If not, the case returns to court. Used together, these approaches can deliver swift, proportionate outcomes, reduce the number of cases entering or remaining in court, give victims a voice, and conserve judicial resources, while preserving safeguards for serious cases that require adjudication. The role of ADR within restorative justice: out-of-court resolutions and deferred prosecutions. Upstream, ADR-style mediation can resolve low-level community and relational disputes before cases reach court, supporting appropriate OOCR decisions. Alongside RJ, ADR techniques strengthen restorative justice by structuring dialogue and translating outcomes into clear voluntary agreements. During deferred prosecution, ADR can help agree, monitor, and adjust compliance terms, reducing unnecessary returns to court. Downstream, ADR resolves civil spillover issues, compensation, housing, workplace disputes, without burdening civil courts. The safeguard, ADR remains voluntary and is unsuitable for serious violence or safeguarding risk cases. Structural reform in criminal courts. Judge-only or magistrate-led trials for specified offences. Potential intermediate criminal court tier. Targets Crown Court backlog directly. ADR as immediate relief in the civil courts. CMC-certified mediation is already operational. High settlement rates and low legal risk. Fastest lever for freeing judicial capacity. Restorative justice and diversion. Appropriate for non-violent, lower-level offences. Avoids trial entirely in suitable cases. Requires strict eligibility criteria. Early triage and ADR assessment. This filters unsuitable cases early, reduces ineffective trials, improves case allocation system-wide. What each tool fixes. CMC mediation, civil courts, high impact. RJ and OOCRs, magistrates courts, moderate impact. Structural reform, Crown Court, essential impact. Strategic conclusion. ADR protects court capacity. Structural reform addresses serious cases. Only a layered approach is sustainable. Which raises the question, can the UK Law Commission support court backlog reduction indirectly by recommending simpler or clearer law, reducing litigation complexity, proposing procedural consolidation, for example, rationalizing offences, suggesting sentencing reform that affects prison pressure. The CMC Code of Conduct sets a professional and ethical standards for CMC registered mediators operating in England and Wales. It is designed to ensure mediation is delivered with integrity, competence, and fairness, and that public confidence in ADR is maintained. The core principles: 1. Independence and impartiality. 2. Competence and professional standards. 3. Voluntary participation and self-determination. 4. Confidentiality. Crucial element, confidentiality. 5. Fairness and equality of participation. 6. Transparency on process and fees. 7. Complaints and accountability. Contributor, me, Jack McKenna, CMC certified mediator, available for virtual pro bono mediation. I think I said a baker's dozen pro bono mediations. Supports non-binding mediated settlement agreements, MSAs. Jack McKenna, CMC certified mediator, Jack_McKenna at mediationintexas.com. Thank you for your time and attention.